with that, we are really happy to hear next from one of the leaders in the digital health ecosystem, one of the legal leaders, and an important advisor to many digital health companies and executives within those companies, Linda Malik and her partner, Jason Johnson, from the law firm Moses and Singer. Again, thank you both for joining today.
Thank you so much, Stan, and I'm so happy to be here. I'm actually here with two of my partners, Jason Johnson and Howard Fisher, and together we do a lot of work in the context of assisting and counseling life sciences companies, both in their early stages, but also throughout the life cycle of the companies, including when they become public, on issues related to compliance, preparing to go public, and other issues. I head up the healthcare and life sciences practice, as well as the privacy and cybersecurity practice at Moses and Singer. Jason, my partner, also specializes in those same areas. And Howard Fisher has a long and illustrious history at the SEC. And so what we're going to be talking about today are mainly those issues that emerging companies should be considering on the road from startup to public company. And we'll talk about some of the things that you need to think about, important key points, and what to look out for along the way. So with that, why don't we go to the next slide? And while that is happening, I will talk a little bit about some of the things that we really want to make sure that you understand. Startup companies and emerging companies in the first initial stages of getting financing really aren't thinking about the long game. They may be thinking about going public at some point, or being acquired as part of their long-term business plan. But what's really important here is that that run-up to becoming public includes a lot of hurdles and compliance issues that you need to think about and need to really pay attention to, because once you do become public, there's a lot of scrutiny, both from regulatory agencies and from your shareholders and investors. So the importance of thinking about all of these things will prevent you from having to deal with due diligence hurdles by investors, for example, delays and difficulties in going public, and then ultimately, hopefully avoiding litigation that could happen if things are revealed that are not in line with what you have indicated to your investors is kind of your company compliance profile. So today we're going to address some of those key initial company issues that you should consider. We're going to be covering three main points, and let's go to the next slide and we'll see what those are. So today we're going to be talking about cybersecurity and disclosure issues, insider trading concerns, particularly for healthcare companies, and then human capital disclosures, which is an area that has really been evolving much more recently in terms of scrutiny around disclosures of what your plans are and what your company looks like in terms of its human capital. First, let's talk about cybersecurity and privacy disclosures. Let's move to slide 3. Cybersecurity is really an issue for all companies. Let's move to slide 4 and we can dig into that a little bit more. It's especially important for companies that are considering IPOs, but also for companies that are considering going public generally. And there are three types of issues that we're going to talk about: both internal breaches by partners or vendors, as well as some of the new FTC rules regarding apps. let's go to slide 4 and we'll focus on internal breaches first. Slide 5, sorry. So what we talk about when we talk about internal breaches are breaches, security breaches that happen within your own company and that deal with your own issues. So we're not talking about a breach by a vendor that may affect you. We're talking about a breach of your own system. And there are a lot of things to consider here. We won't go into all the nuts and bolts of how to secure your system. Our attorneys do counsel our clients on those sorts of issues quite a lot. But what we're really focusing on here is disclosure, providing notice and disclosure. So if there is a breach to your system of individual information that you may hold, the initial reaction may be, okay, let's just deal with this and then move on. But that is a mistake for a number of reasons. First of all, there are both a patchwork of state laws throughout the country that require that you provide notice and disclosure to both individuals and oversight agencies if there has been a large-scale breach. What we're not talking about here are security incidents like pings and attempts to access that are unsuccessful, but rather really significant large-scale breaches. So here, what you need to think about is, what is your plan for dealing with a breach in order to comply with state laws, any federal laws that could apply, such as HIPAA, which also has its own disclosure requirements. And then how are you documenting that you have made that disclosure? Do you have shareholders that you need to disclose this sort of event to? Because once you go public, there is going to be scrutiny as to whether you made appropriate disclosures, who you made those disclosures to, and what we're seeing is a lot more scrutiny around proper disclosure and proper management of security breaches. So notice and disclosure is essential in that context. The SEC has brought multiple enforcement actions against companies for failing to adequately disclose breaches. So even prior to an IPO, if your company has suffered a major security breach and that has not been adequately disclosed, that could lead to an investigation by the SEC, which is something that we don't necessarily think about before going public. It could also lead to a securities class action, another thing that may not be at the top of your mind at an earlier stage, but really should be as you're thinking longer term. Let's move to the next slide, where we have talked about government enforcement. Let's move on. So, as we've talked about, we've got two different risks here: public enforcement actions, as well as investor actions. Investor actions and actions by shareholders are quite important and issues to consider. Let's move to the next slide. One other thing to consider here is that your own systems and a breach to your own systems directly are not the only issue. There is a very important consideration with respect to vendors that you use that may be completely separate third parties, not at all part of your employment or part of your system, but rather vendors that you rely on for various things, such as cloud storage or software support and so on. What we have seen in the last 3 years or so is that there has been a real uptick in breaches of vendor security systems. The SolarWinds breach that happened last year was a really big one. It was a large-scale security breach. SolarWinds being a very large software company with about 33,000 customers that use their software systems. And of those, about 18,000 were affected by this breach. So very, very large-scale breach that affected not just SolarWinds, but also many, many of its customers. This was a breach allegedly infiltrated by Russian intelligence. But what is interesting about this is that not only was SolarWinds investigated, but in this past year, the SEC has issued a large number of subpoenas to companies that were affected that contracted with SolarWinds as a vendor. And so clients of SolarWinds are now being scrutinized by the SEC, which is looking at the measures and procedures that were taken in response to the breach and looking at whether the scope of the breach was properly and fully disclosed and disclosed on a timely basis. So again, I think the thing to be really, really cognizant of here is that companies that are not yet public are probably pretty familiar with the patchwork of privacy laws and security laws that I've mentioned, requiring different types of measures, different types of disclosures, but there's this whole added layer of enforcement and scrutiny that is public once you become a public company, that is even more significant in many ways, because the failure to adequately disclose a vendor breach that affects you could cause significant reputational damage, could cause litigation, could cause enforcement actions. So when thinking about your security program in the run-up to becoming public, it's important to consider not just your own program, but also your vendors as well, and how that might affect you. There are other issues to consider here, which we won't go into in detail, but I will mention that we do a lot of work with companies that utilize vendors like this with respect to helping them do due diligence on their vendors. And that is another thing that gets scrutinized in this context. Did you do adequate due diligence on your vendors such that you put yourself in a position to be less vulnerable to a breach by them? So accountability in the context of breaches by vendors is huge and something to really be mindful of as you move toward compliance and as you move toward becoming a public company. Another thing to talk about here is recent guidance that has been put out by the FTC related to healthcare apps and other apps. And I'll turn it over to Jason to talk about that.
Thanks, Linda. So as Linda mentioned, the FTC has put out a statement recently in September where it reminded folks in the digital health and digital app space that they are subject to what is known as the health breach notification rule. So the health breach notification rule has actually been in effect since 2009, and it fills a role in a gap with regards to HIPAA. So if you're a HIPAA covered entity or you're a business associate, then the FTC breach notification rule, it doesn't apply to you. But with the increase in the amount of digital apps that were out there and the collection of health information, the law was passed to ensure that this gap was closed. And so there has been some enforcement by the FTC since it was passed in 2009. But with the most recent policy statement, this has now come to the forefront on the digital side as we all get more digitally connected and with the explosion of digital health apps that exist out there. And really, there's sort of two parts to the FTC enforcement that you need to be aware of. So the first is your privacy policy disclosure, and the second is a data breach itself. As Linda mentioned earlier, digital in the digital health space, is really important that you have a privacy policy that's both accurate and fulsome enough to give the full scope of the information that you're collecting and the disclosures of that information that you're making to other entities. And there have been enforcement actions by the FTC recently that have involved actually a health app company that did not adequately disclose what they were collecting and how they were disclosing information. So there was a settlement that came out in February of this year with Flow Health. So Flow Health is a menstrual cycle health app that helps women track their menstrual cycles. And what they were doing was that they had said in their privacy policy that they were not disclosing information to any third parties or sharing it. Well, it turns out they actually were doing that. So the FTC came down on Flow Health and required them to actually obtain consent and a separate consent notice for the sharing of the information they were collecting with third parties, which is really the first time that's actually happened from the FTC point, where the health app was required to make this disclosure and go through this consent process. So it really is important that when you are a startup, you're trying to get whatever partners and business that you can. And so a lot of times we've seen where people will say, well, we'll just kick this issue down the road, it'll be fine. Really and truthfully, with the scrutiny that the FTC is now placing on digital health apps, you really can't do that. So it's important that you're structuring your relationships in the manner that's consistent with what your privacy policy is. And there's no reason that you can't tell people in the privacy policy what you're doing. A lot of times people are afraid to say, well, I'm collecting this data and I'm going to share it with these third parties for these purposes. It's actually more important to be honest and truthful up front so people know what you're getting into than it is to try to hide the ball on that, because you may get in trouble if it's found out that you're actually sharing data when you say that you're not in your privacy policy. So really, this is an iterative process. A lot of times people, particularly startups, will have someone help them draft a privacy policy. They'll put it on the website and then they won't look at it again. And as their business evolves, they don't go back and think about, well, does my privacy policy actually align with what my practice is? So it's really important that A, you have a privacy policy that's in place, and B, you have some sort of procedure in place to make sure that as your company evolves and changes, that you're actually updating your privacy policy to be in line with what your practices are. Now, secondly, is the purpose of the health breach notification rule is really notification of a data breach. Okay, but let me take one step back and clarify or make it clear who the health breach notification rule covers. So the health breach notification rule covers entities that have personal health records. Again, so we're not talking about HIPAA, so it's not HIPAA covered entities here. But what a personal health record is it's a collection of data that includes medical, mental health, or other types of information like that, along with personally identifiable information. And that has to be collected from multiple different sources, meaning if your app is exclusively filled with data that the individual person puts into the app, then you are not a personal health record. Where digital health companies get in trouble quite often with this is that they may have some sort of API or some other process in place where they're collecting data, say, from the individual's phone. So for example, when you set up your software, you may say, well, I want permissions to collect data from their calendar or their contacts, right? So once you start crossing that line and you're integrating the data that you're collecting with what the individual is inputting in there, then you may actually be considered a PHR. So again, from a structure perspective, if you're thinking about whether or not the FTC applies to you, it is important that you understand whether or not you've inadvertently created a situation where you're subject to this rule but you don't realize that you are because you think that you've made the information that you're collecting just from the individual. So again, looking at how your software works and where your data is collecting, if you're getting this identifiable information or information about the person from another source, whether it be their phone or from another outside source, along with this health information, then you're going to be covered under this rule. And so once you're covered, then we have to talk about what a data breach is, right? So typically when people think of a data breach, they think of, oh, someone hacked my system or we got a ransomware attack. And situations like that are certainly covered. But going back to the Flow Health situation, what people may not realize is that inadvertent access or disclosure to individuals who should not have access is also considered a data breach. And so whenever that situation occurs, again, it's important that you understand that A, now you have a responsibility to make a notice, and B, that you have some sort of policy or procedure in place to either make the notice or to reach out to outside folks that can help you understand who your notice has to go to, because there's a lot of different variations as to who the notice has to go to depending on how many people's information has been breached. So again, you want to make sure that you're making the right disclosure to the right folks in the right time frame. And so, there's both 10-day requirements and 60-day requirements, depending on what type of data breach that you've had and what type of information it involves and how many people it involves. So it really is important that you do understand whether or not you're subject to this rule, and that you understand that if you have a breach, that you've got notification obligations and you make those. And that was really what the point of the policy statement was to reiterate to individuals that are, companies that are covered by this health breach notification rule, that if you are disclosing data to someone that you shouldn't, or someone gets access to it, that is a breach. And you do need to follow through and make the appropriate notifications. Otherwise, you're going to be subject to potential FTC enforcement and penalties. And what are those enforcement and penalties? Well, they're actually pretty significant. So the way the law is drafted is that you can get civil penalties of a little over almost $44,000 per violation per day, right? And so the government is very good at drafting language that gives itself flexibility to say that, well, each time someone accessed this for all these people, that is a violation. So instead of one violation that covers everyone, I'm going to give you 100 violations. And so now you have, over $400,000 in potential fines just from day one. And this happened for multiple days. You're looking at a very significant fine. So there are some teeth to this law and regulation. So it's not going to be a slap on the wrist. And based on the fact that the policy statement came out, as well as the recent enforcement actions that we've seen, this is something that you have to take seriously and be aware of as you move forward. Now, the other statement that came out from the FTC as part of this was the cybersecurity, what they call cybersecurity best practices for mobile health apps. And again, when we're talking about privacy, we're talking about disclosure. When we're talking about cybersecurity, we're talking about the protection. And so a couple of key takeaways that came from this best practices is first and foremost, and this is a good data hygiene situation to consider, which is only collect what you need. Quite often, when you're in the digital health space, data is also valuable and monetizable. So you want to get as much information as you can. But just keep in mind that the more data that you have, the more vulnerability you have to enforcement actions, right? And so because now you've got information in your possession that you may not actually need, and if there's a data breach involving that, your obligations are still there. And so, first and foremost, as you move forward in this, it is important to say, okay, can I get away with not collecting this data? Second is they mentioned, like, can you de-identify it? Again, I know in a lot of instances, health apps aren't able to really necessarily de-identify data as part of what they're collecting, but as far as disclosure to additional companies, it may be a possibility to de-identify this data so you can avoid the situation where you get identifiable information over the third parties. And the reason that's important is, as Linda mentioned, you are also responsible for your vendors and anyone else that you give this data to when you collect it. So you may inadvertently create liability for yourself by disclosing identifiable data to another party that then has a data breach that then obligates you to be responsible to the individual because you're the one that collected it. Going back to what I mentioned before about with the software and the API that you're using, again, it's important to pay attention to the permissions that you have. Do you need all the permissions that you have? Again, the more data that you have, the more potential responsibility. When it comes to your vendors, vendor due diligence is really important and really key. And the reason in this space in particular is that as there has been an explosion of the digital health apps, there's been an explosion of vendors to help those digital health apps, whether it be cloud service providers or other entities that you're working with. So it is very important that you have some sort of diligence procedure in place to make sure that you are properly vetting your vendors, particularly on their cybersecurity side, and have rights and obligations in your contract with them to be able to do testing or to ask questions to confirm that they have, appropriate cybersecurity policies and procedures in place. Because for the most part, a breach of your vendor is your responsibility. And so, on the contractual side, it's important to have those, requirements in place, but also think about identification when you get to the contractual level. And again, that's why, when you're thinking about the contracts with these companies, quite often you may feel like you're a small fish in a big pond and they hand you a template and there's a lot of terms in there that just aren't very friendly to you, putting all of the liability and obligation on you, and the other side doesn't take any responsibility. It is very important that you do as much as you can to avoid those contractual obligations and to protect yourself. And so again, in a lot of instances, you should be able to at least think about negotiating. And if you can't, it is important that you think whether or not there's someone else that can help you, and is this really the best choice for you as a vendor. And then as far as your own security measures, again, if you're housing the data or if you have employees, it's important to test your own, security measures, update your software, do training. People are the biggest reason that ransomware attacks and other cybersecurity attacks occur because they click on things that they shouldn't. And I can tell you from experience helping other clients, ransomware attackers are getting more and more sophisticated, and they're getting better at making things look real and legit than in the past, and they're only going to continue to evolve and get better because it's a money-making scheme for them. So again, for your own house, you need to make sure that you've got some sort of policy procedure in place to have the IT folks regularly update software and make sure that your security measures are in line with what you're required to have. And so with that, that's really the public enforcement. And as a startup that hasn't gone public yet, where these issues generally come into play is from the investor standpoint, right? And so it's important that you align early on in the development of your company to make sure that you are aware of the obligations that you have, and you really structure yourself in a way that you can continue to grow where you're growing in a compliant manner. Because it's often quite hard to go back in time and fix things when you've collected data in a certain manner. Because if you've told someone in a privacy policy that we're never going to disclose your data to third parties, and now you want to, you may not be able to, because you may have to go back and reconsent those folks or and disclose to them what you want to further do with the data. And then it may not be feasible. So it is important that you structure this appropriately up front, think a little more long-term on your business side, and that will hopefully help you avoid these issues going forward. But on the private side, and I'll turn over to Howard to speak more on that. But on the pre-IPO side, you can also be sued for potential breaches on private litigation for the statements and the actions that you've taken even before you launch an IPO. And I'll turn over to Howard to speak a little bit more about that.
Thank you, Jason. And I'll just touch briefly on that before going into insider trading issues. Can everyone hear me? Am I on? Great. First of all, if you have suffered a breach before going public and you don't disclose that as part of going public, you are liable. Your investors will sue you if they connect that to any loss in value. And the fact that you can do this has actually been reconfirmed just yesterday. There was a case against Clover Health Investments, which is going to get a lot of press because Chelsea Clinton is on the board of it, and they have been sued both in a securities class action and in a derivative suit for failing to disclose improper billing procedures from before they went public. So there's clearly a lot of litigation and potential risk and exposure for companies that have these breach issues before they go public, if they go public without disclosing them. So what I would like to talk about in greater length is insider trading concerns. And as Linda said in her introduction, I am a former SEC senior trial counsel from the New York office. I've prosecuted insider trading cases, and insider trading cases run the gamut, basically from easy to prosecute to hard cases to prosecute. And the easy cases are, frankly, a lot of the ones involving the healthcare space. Healthcare companies are uniquely situated in a lot of ways to be the subject of insider trading prosecutions, because healthcare companies often have their financial health depend on one key event. It could be approval by the FDA, it could be a major contract, more than any other companies, and especially for startup companies or emerging companies, one singular event could have a drastic effect on business prospects as well as on stock price. And so there is a temptation to use some of this information, perhaps to trade on the securities of the company, because if you know the information, you could front run the market and do quite well of it. As a lawyer and former trial counsel from the SEC, my advice is, well, just don't do that. This is a huge point of emphasis for the SEC. Healthcare insider trading cases are probably one of the largest blocks of insider trading cases that the SEC brings. So what I'd like to do is focus on a couple of recent cases, see what lessons we can draw from those cases, and then see where we think the SEC is going and what we could do to avoid being in the crosshairs of the SEC. The first case I want to focus on is SEC versus Barry, which came out earlier this summer. Mr. Barry, Dr. Barry, was a medical investigator who was hired by Karuna Therapeutics to help develop a drug. In the research for this, he signed a confidentiality agreement that said that, except for the limited purposes of conducting the trial, he wasn't to disclose any confidential information. He was then informed that clinical results were very positive, and he was going to be designated for the investor contact team to help tell investors how good the information was. And by the way, the information you're getting is confidential until it's disclosed to investors. So what did he do? Before the results could be disclosed, he went to his work computer, traded, the results were disclosed, and he made, I think, a 300% gain, which he all had to give back, and then he had to pay a penalty on top of that. The key part of his case, or the case against him, was the confidentiality agreement that he signed. Now, is it just insiders who trade who could be liable? No. After this case came another case, SEC versus Calise. And what's interesting about this case is that Mr. Calise was not an insider, but his wife was. His partner was a senior project manager overseeing a clinical drug trial. She had executed a confidentiality agreement with her company, and she had also executed an annual acknowledgement saying that she understood her obligations, she understood that the information she obtained in the course of her work was confidential, and that she shouldn't disclose it. Then she learned that the results of the test were negative. She didn't trade, but she tipped her partner and told him that the results were going to be negative, and so he should sell all his shares before those results were made public, and the share price would go down. Well, that's a bad thing. He was prosecuted, and she was prosecuted for providing him the information. Can we go to slide 10, please, the next one? So what are the two takeaways, a couple of takeaways we can get from these cases? First of all, regulators are remarkably sensitive and good at ferreting out insider trading. In any instance where share prices fall or rise dramatically in connection with the release of market moving news, regulatory authorities will review the trading records. Anything out of the ordinary will be flagged, will be followed up on, and will be investigated. And if it turns out to be bad, it will be prosecuted. Second, tippers who themselves do not trade on this information can still be held liable and themselves compelled to pay a significant penalty if they provide that information to other people called tippees. And then the tippees, even if they themselves aren't subject to the confidentiality agreements, can themselves be held liable for trading on material non-public information. And let me just reiterate this because it can't be, you can't stress it enough. The SEC and FINRA and all the regulatory organizations that oversee the stock markets have a lot of tools at their disposal. And through those tools, they can figure out who's been trading and whether or not they have any connections to the company. Next slide, please. So what should companies do to protect themselves? The first thing is they should develop, implement, and clearly communicate to all employees and contractors policies that explicitly prohibit any communication of material non-public information. And this specific written agreement should be executed by all employees and contractors. It's not enough to simply say this. It has to be written down if you want to avoid it. And let me just point out that even if the company is not involved in insider trading by its employees, it could be held liable for that if it failed to have appropriate systems in place to protect against this possibility. Next slide, please. In addition to having these policies, there should be regular affirmations, either on a yearly or twice a year basis, and in-person presentations as well, that stress the importance of these rules and the potential adverse results that could happen if people breach it. And I would argue and suggest that these be in-person regulations. Having someone issue a checkoff box on a computer screen doesn't have the same effect as an in-person presentation once a year where you sit people down and you say, here are the obligations, here's what you have to do, and here's what you're not supposed to do. And this communication should include not only about the risks of insider trading, which are financial penalties, but the reputational damage as well. People who are found liable for insider trading never work in the industry again. And a lot of them made maybe 10, 20, 30, $50,000 of profits. And for that, they've basically thrown away their career and they are unhirable. And again, I would suggest that in making these presentations, you stress not only how problematic this is, but you also stress how good the government is at finding out this information. The government has remarkable resources, and in fact, I miss them. As a private lawyer, you don't have access to the same information that you did as a government insider. You could track trading, figure out who traded what, figure out what computers people traded from. I mean, it's truly remarkable what you could find out. And many non-professional traders simply don't understand how easy it is to track their trades. They'll, make it from their home phone, or they'll tell a friend to make the trade from that for them. All of this can be tracked. So you may be thinking that, well, you're not a public company, and so you don't have to worry until you become a public company. There's no real risk for you. That's not necessarily the case. First of all, you should have policies in place before you go public, because it's not enough to put them in when you go public, because that point of going public or being acquired is an event that could be the subject of insider trading. The second thing that people should be worried about is what is known as shadow trading. And here's a little confession of mine. When I was at the SEC, one of the things that law enforcement officials do when you prosecute a case is you figure out how they could have gotten away with it if they were smarter. What's the way to achieve the same results without technically breaking the law. And I hope my fellow enforcement officials aren't going to, get upset that I'm disclosing that. But one of the things that we used to talk about was, well, what about if you get insider information and you don't trade on your own company stock, but you trade on other company stock? Let's say there are 3 companies researching Alzheimer drugs. You crack it. You figure out something and you figure out, well, those other companies, no one's going to want their drugs now. And so you short those companies. That's what has been known as shadow trading. It was an open question, frankly, until just recently as to whether or not that was illegal. And that open question has been answered a few months ago in U.S. District Court for the Northern District of California. One Matthew Panawat, who was an insider at a healthcare company, traded the securities of a competitor once he realized that his company was going to be acquired by Pfizer. He was prosecuted. Now, does this mean that we're going to see a huge onslaught of cases involving insider trading? There have been people who have been calling for this, and there's a lot of data out there and research out there that purports to show that executives trade in the shares of other companies and try to make a profit using inside information they get from their own company. But I think that the Panawat case is a little bit unusual, and it's probably not going to be the onslaught. First of all, he agreed to use the information he got confidential. And secondly, he also agreed that he wouldn't use the information he got, not only to trade in stocks of his own company, but of other companies. The other interesting factors were he actually made the trades on his home computer on his work computer, a few minutes after learning the news. He actually was told the news and said, excuse me, I'll be back, went to his computer in his office and made the trades. And these were short-term out-of-the-money trades, i.e. trades that were likely to lose money unless there was an almost immediate release of market-moving information. So while those are really, really bad facts, and hopefully there's not a lot just like that, what it does point out to is the importance of companies adopting policies that clarify how essential it is that employees keep material non-public information confidential, including not just to trade the shares of their company, but shares of other company. And I know this becomes an issue with what you could get from employees, but if you could have employees agree not to trade shares of any healthcare companies, I think that would help you and help them avoid liabilities. I want to move on to another subject, human capital disclosure risk. Move to the next slide, please. So over the last year, there has been an really remarkable ferment, as I think Linda alluded to earlier, on federal workforce regulation. And I don't think it's an exaggeration to say that we've effectively seen a federalization of the HR function. What I'd like to focus on are recent changes to reporting rules and changes that we are likely to see in the very near future. Can we go to the next slide? So on August 26, 2020, the SEC announced amendments to Reg SK, and this is the regulation that involves what companies have to disclose on a periodic basis, either in proxy statements or annual reports. And these rules apply to all public companies. And these amendments came effective at the end of last year in November of 2020. And what's interesting is what these disclosures require. Among the things they require is a description of, and I'm going to read just the highlighted language here, any human capital measures or objectives that the registrant focuses on in managing the business. Next slide, please. So you may ask, what does this mean? I mean, it's a remarkably ambiguous language. What are human capital measures? What are the objectives that you focus on in managing the business? And so, it's typical when the SEC announces new rules that they define what the terms they use. And what's interesting is that the SEC explicitly declined to do so and said, quote, this term may evolve over time and may be defined by different companies in ways that are industry specific. Partly this reflects a political dispute as to how far to go, but the fact that the SEC required additional disclosures of a subject that it then refused to define creates significant difficulties and difficult circumstances for corporate disclosure. First of all, there's the question of what does it mean? Issues or measures or objectives you focus on in managing the business. What if you don't focus on retention? If you don't focus on diversity in management ranks, does that mean that you don't have to disclose it? Now, recently, and this has actually been a pretty substantial change, under the new chairman, SEC Chairman Gary Gensler, the SEC announced that it was going to look at even more stricter rules. And there has been a lot of pushback on the ambiguities that these rules created. And it will come as no surprise to most people that these rules, like anything the government does, is highly political. And these often are done by 3-2 votes. Under the Trump administration, there were 3 Republicans and 2 Democrats. Under the Biden administration, there are 3 Democrats and 2 Republicans, which means we're very likely to see a lot of very strict and additional rules that are pushed out on disclosure issues, especially around the issues of diversity. Every year, the SEC lists its regulatory priorities. This year, in doing that, one of its priorities listed was imposing stricter rules on human capital disclosure, including potentially requiring data about workforce diversity, employee turnover, number of full-time versus part-time employees, and so on. And we'll talk a little bit about this more later, but one of those big issues for the SEC is diversity. Diversity not only on the board level, but also within the company. And this has been an issue going back for the last year or so, ever since the change of administrations. And you see it in a bunch of different realms. Can we go to the next slide, please? If you are a Nasdaq listed company, or you're thinking about becoming a Nasdaq listed company, there are additional listing requirements which the SEC just approved, and these are the Nasdaq diversity listing requirements. If you are listed on Nasdaq, you must disclose board level diversity data that includes gender, ethnicity, LGBTQ status, and there's a very complex matrix that I don't want to go into in detail here, but that's the gist of it. And then Nasdaq companies have to disclose what the diversity of their board is, and if they don't have at least 2 directors who are diverse. If you don't have 2 directors who are diverse from one of these categories, then you have to describe and explain why you chose not to meet those requirements. And this is a federal rule. If the Nasdaq rules apply to any companies listed on Nasdaq, but there are many other states that are also leading the way on this. California has similar requirements. If you're a California company, you have diversity requirements in your board, and it's not just a government requirement, but this has become the subject of a lot of litigation action as well. I haven't counted in the last week or so, but the last time I counted, I think that there were well over a dozen class action lawsuits against companies for alleged diversity failures. The next slide, please. So why does this matter if you're not currently a public company? First of all, these are the requirements that will apply to companies as they are going public, or that might be acquired by public companies. Even if your exit plan is not doing an IPO, if the exit plan includes an acquisition, your disclosures, your corporate makeup becomes a disclosure obligation for the acquiring company. So if it turns out that every single person at your company is a straight white male, that is or could be a problem. It could be a problem not only for the regulators, but for investors as well. And I take to heart some of the comments by the keynote speaker who preceded us, who talked about the importance of diversity and the importance of increasing the number of different perspectives that companies have. And it's not just a matter of this is a good thing and we should do it because it's good for society, but it's also a legal obligation. So what are the action takeaways from this? First of all, could we have the next slide, please? Start thinking about human capital disclosure now, before going public, before getting into discussions about acquisitions or combinations. Knowing investor and disclosing concerns now, you can situate yourself so that you're not forced to scramble at the last minute. And it is a lot easier to be prepared for something and then do it than to not be prepared. I'm going to turn this in, and when we go to diversity issues, I want to turn this over to Linda, and to the next slide, please.
Thanks, Howard. Before we move on, I'm going to pause for just a moment because a question came in that I want to make sure that we address. The question is, for global transactions, what are guidelines or regulations for which countries' data policy regulations will be adopted? In other words, what countries' rules do you follow in a global transaction when it comes to data policy requirements? And I'm assuming that that includes data privacy issues. So this is sort of a good news, bad news scenario. The bad news is that you really have to comply with every single country's requirements in which you operate or in which you collect data. The good news, though, is that this is not an impossible task. And in fact, what we typically do is we counsel our clients to try to follow the most stringent countries' requirements. So right now, for the most part, I would say, look to the EU. The EU has really been the leader in this area. Other countries have followed suit and also have very robust protections and requirements around data privacy, security, just handling of data. That would include India, for example. But following the most stringent requirements at least puts you in the position of having a best practices approach. And that is what we help clients to do, is employ a best practices approach so that you're not necessarily just flooded with conflicting or complementary requirements all across the globe. Happy to talk about this further offline. You can feel free to reach out to us, but that's the general answer that I would give to that question. So let's.
And Linda, let me just jump in for a second to add that the same also holds true for human capital issues. The EU and some Latin American countries are significantly ahead of the US on this. So if you have operations overseas, these are considerations that you should be considering as well.
Yeah, excellent point. Thanks, Howard. So let's talk just a little bit more about diversity. And as Howard has mentioned, there has been a lot more activity around this issue in the last year. And diversity matters. We know that it matters. It matters a lot, and it matters for a lot of reasons. As Howard said, it's not just that it's the right thing to do and good for society, but we now know that it's a requirement, and there will be scrutiny around this by federal regulatory authorities. So aside from federal and state regulators, it also matters to institutional investors. It matters to plaintiffs' attorneys. The number of diversity shareholder proposals over the last year has gone up tremendously, and it continues to increase. So the main takeaway here is that you need to come up with a plan. You need to stick to that plan. You need to determine and come up with a plan to determine metrics in order to figure out how you're going to deploy your plan. The plan needs to be qualitative. It needs to be quantitative. In terms of the industry, the healthcare, biotech, and pharma industry now, I think the industry is really on the front lines of this generally, and so that's a good thing in terms of being on top of this issue. What's interesting about that is that, as Howard mentioned, the SEC has not identified specific guidelines that companies need to follow. So it is up to the company, but what they have said is that in terms of what they scrutinize, and I'm going to quote here because I think it's worth quoting. The SEC has said the exact measures and objectives included in human capital management disclosures may vary significantly based on factors such as the industry, the various regions or jurisdictions in which the registrant operates. So the SEC is looking at context here. It's looking at what the industry is doing generally to address diversity issues. And if you are not in line with what the rest of the industry is doing, that could subject you to scrutiny. It could be considered a violation from the SEC standpoint and put you in a position where you're vulnerable to enforcement action.
And let me just jump in and say it also exposes you to potential class action by investors as well as derivative cases against the board of directors.
Right. Thank you. Yes. So again, the main takeaway here is it matters. Putting in a plan that can be measured matters, and that making sure that you're in line with what the rest of the industry does is important to protect you and your company from various lines of scrutiny and potentially litigation. Let's move to the next slide, and I'm going to turn it back over to Jason to talk a little more about this issue.
Thanks, Linda. As Linda mentioned, it is important to develop a system or a set of metrics to be able to evaluate and disclose the diversity measures that you're putting in place. But it's also an important issue from a enforcement standpoint. Right now, the SEC is actually actively investigating Activision for its disclosures related to diversity. And what it's looking at is, and it's asked for internal emails and other communications that deal with the diversity issue. Because what it's trying to do is align the metrics that it disclosed with what was actually going on internally. And this is really the important point when you're thinking about it from an enforcement perspective, right? Because the public disclosure needs to be accurate and it needs to be truthful. And if you're inaccurate or you're not disclosing appropriately, then you may be subject to enforcement action. So the consistency part over time will help you to develop a standard set of metrics that you can use that will hopefully align with what you are actively internally doing when it comes to diversity measures. And if the SEC or an investor or anyone else brings an enforcement action or a litigation, you can then rely upon those consistent metrics and the information that you have to hopefully defend yourself. So again, the consistency is really meant to make sure that you are aligning with what your actual policies are in case one of these enforcement actions arise. And next slide, please. And then I think the final thing to talk about in this case is engaging with your core constituencies. And what am I talking about here? In particular for startups, I'm really talking about on the investor side, right? Because this is a disclosure requirement, the folks that you're asking to invest in your company may ask you questions related to this. Like what type of diversity do you have? What type of diversity measures are you going to put in place? What's your plan going forward? And the reason that's important is that from an investor standpoint, your plan may not align with what's important to them. And so, as you go forward with, trying to engage in investors, it is important that you think about these issues up front and you have these conversations with your investors to make sure that you're strategically aligned. Because if it turns out that you don't have this conversation and perhaps you aren't aligned with your investors, it may be in the future that they decide to part ways with you. So it is important that you engage with the folks that are going to be part of the investment community as well as part of your employment community to make sure that you've got a stable workforce and stable investment. So with that, I think that generally concludes our talk. If you want to go to the next slide. As mentioned, this is our contact information, as Linda said. If you guys have questions after us, please feel free to reach out to us we're happy to talk.